we will start now. I'm Randy May, president of the Free State Foundation, and I want to welcome you warmly. I say warmly with the day's weather outside in mind to our program today, which is titled Privacy Regulation: Why, What, and When. So we're going to be focusing today on privacy regulation, of course. One thing I want to say, really, when it's so great to see such a wonderful crowd here. That's a tribute to our speakers, of course, and maybe the food to a much lesser extent, but it's really wonderful. I want to say one day we're going to really enforce that, at the bottom of our emails where it says you must register to attend. It's on every email, and we love having everyone here and providing lunch, but there are a few people here that didn't register, and we love to have the big crowd, but just adhere to that admonition or plea, if you would, in the future. Okay. Once we get all the cell phones quieted, then we're gonna go. So we're here in the First Amendment room today. Now, I know many of you are regulars here. I know that when I look around, and you've heard me say many times that I like to be in the First Amendment room, right? You've heard me say that. At FSF, many of the issues that we deal with, of course, in the communications policy area and internet area implicate First Amendment issues. And in our work, if you follow it, you know that we consistently try and articulate strong support for First Amendment protections, and that doesn't matter who the speaker is and what the position is, but I think we try and take a principled First Amendment position, and we try and do that with our view of the First Amendment properly understood. I'm just going to take a minute to digress, and then we're going to be right back to privacy. But I said properly understood because it seems to me that the free speech clause is often misunderstood, and more so today than maybe ever before. But you just hear, not a day passes really where you don't hear someone complain that their First Amendment rights or their free speech rights have been denied because some post has been taken down from Twitter, or some post has been deleted from Facebook. Or maybe someone wants to come up here and take the mic away from me right now and claim that their First Amendment rights have been violated. And you hear that all the time. So all I want to say about that right here in the First Amendment room now is that on June 17th, in an opinion for the Supreme Court in the Manhattan cable access case. This involved public access channels, but Justice Brett Kavanaugh wrote a really important opinion, I thought, in that case that I would commend to you if you're interested in the First Amendment. And I just want to quote something he said there that's relevant to this point that I'm making. He said, "The text and original meaning of those First and 14th Amendments, as well as the court's long-standing precedents, establish that the free speech clause prohibits only governmental abridgment of speech. The free speech clause does not prohibit private abridgment of speech." That's a fundamental foundational principle, but it's just so often, misunderstood, really, when people talk about the First Amendment. Okay, so now enough about that, and on to today's topic of privacy regulation. I don't want to take any time, actually, and I don't need to with you to belabor how important and how topical, even we could say hot topical, really, this subject of privacy is. You know, almost every day in the papers there's perhaps new revelations, or at least some discussion about these questions that we're talking about: why, what, and when with privacy regulation. So, you know, we could devote a session each to the why, what, and when, but with the lineup of speakers we have today, and as outstanding as they are and knowledgeable as they are, I'm sure we're going to cover all of it right here in the next 90 minutes or so. So here's what we're going to do. This is the program. First, in a moment, I'm going to introduce FTC Commissioner Noah Phillips, who's going to give us an opening keynote. Then we're going to have a panel discussion moderated by my colleague, Senior Fellow and Director of Policy Studies, Seth Cooper, who will introduce his panel. And then following that, Senator Marsha Blackburn is going to deliver the closing keynote address, and we're going to wind up at 2 o'clock. Okay, so just a couple housekeeping matters quickly. First of all, tweet away. I think we have our handle on the tables, but it's hashtag FSF Privacy Seminar. So, you know, please tweet. You know, if Twitter takes it down, you don't have a First Amendment right, but do it. I just want to mention briefly, because, you know, this topic hadn't gone away in the last 12, 13 years. I'm speaking of net neutrality, of course. It may not, I'd like for it to be resolved, but it probably will be with us for years to come. So with that in mind, I want to just call your attention to this book that we published here, the Free State Foundation's publication, A Reader on Net Neutrality and Restoring Internet Freedom. I know it's a sexy title, but we called it a reader because it's really a compendium of 20, 25 pieces of work by Free State Foundation scholars and our academic board members, and all of whom are affiliated with the Free State, that we published just over the last 3 or 4 years, not going back further. And it's so, you know, it's highly useful, I think it is, for anyone that's interested in the arguments relating to net neutrality. Now, you know, fair disclosure, as they say, it's, you know, these are articles that essentially make the case against net neutrality. If you want the other side, there's plenty of that out there. Okay, so that's that. Now, finally, I just want to acknowledge today, I think we have all 4 members of our board of directors, 4 members, not of our board of directors, that are here, and I just want to thank them for their service. You know, I don't get a chance to do this all the time, but I want to do it today. We've got Ken Kane is here someplace in the back. There's one. John Farley is, everyone's scattered, but John Farley. Donna Gregg, I think, is Donna? Donna Gregg. And then Tom Talkie. And each one of those contributes to, and has contributed a lot to making the Free State Foundation as successful and impactful as we are, and I thank them very much for that service. And then finally, I want to thank Kathy Baker, our events coordinator. Sometimes I forget to do that, but you can see what a wonderful lunch we have here. I'm not sure whether Kathy's in the, there she is, so let's give Kathy a round of applause. Okay, and with that, I want to ask Commissioner Phillips if he will come up to the podium and just have a seat next to me while I introduce him. So we were fortunate in March when we did our annual conference just a couple months ago to have FTC Chairman Joe Simons give a keynote address at that event, and we're very fortunate today to have one of his colleagues address us at this event, and that is Commissioner Noah Phillips. Now you have the bio in front of you, and so I may give you the really short version with Commissioner Phillips' permission here. But he was a longtime counsel. He joined the FTC in April of 2018. One of the things I think many of you know about Commissioner Phillips and his other colleagues is they came on together as new commissioners, and I think that it may be unprecedented, but if it's not unprecedented, it's very rare. So that's an interesting experience that maybe some other time we'll talk about. But before joining the commission, Noah Phillips was a chief counsel to Senator Cornyn on the Senate Judiciary Committee for a long time. Prior to his Senate service, he was with major law firms, and also before that he worked as an investment banker with a prestigious investment banking firm. His undergraduate degree was from Dartmouth, his JD from Stanford Law School. So of course he's very credentialed, and we're very, very happy to have you with us today. So welcome, please, Commissioner Phillips.
Thank you, Randy, for the warm introduction and the invitation to speak here today. And I want to begin by just assuring you that I did register. Or at least I was advised that I had registered. So I hope that my presence hasn't caused a problem in that regard. It's great to be here at the Free State Foundation, which has such an important mission of using research and educational activities to promote the understanding of free markets, limited government, and the rule of law principles that are critical to our republic. I'm really honored and pleased to be here today with all of you. Let me begin with the obligatory caveat that people in my position have to give, and that is that the remarks that I make today are my own. They are not necessarily the positions, and in fact, very likely not to be the positions of my fellow commissioners, and they don't represent doctrine of the FTC as a whole. Today's event could not be timelier. We are in the midst of a robust debate, nationally and internationally, about consumer data privacy. I could talk all day about this topic, but fortunately for all of you, I've been limited by Randy to about 15 minutes, and I'll do my best to keep it to that. I do want to spend my time today highlighting my priorities for privacy legislation, and to do that, I want to take advantage of the framework laid out in the title of today's seminar, Privacy Regulation, Why, What, and When. I will start with, I can't speak to the when. Maybe Senator Blackburn can speak to that, but I can't. So I'm going to diverge a little and talk a little bit about the how, because I think that's really important too. But let me start with the why. Why we should consider privacy legislation. I see two reasons above all. First, privacy violations can result in real and legally cognizable consumer harms. Using our organic Section 5 authority and statutes like the Fair Credit Reporting Act and COPPA, the Children's Online Privacy Protection Act, the FTC, where I work, has a long history of protecting consumer privacy. Consumers and firms have increased dramatically the amount and use of data in our economy, especially in recent years. So I think it is fair for lawmakers to contemplate whether our current framework necessitates additional or perhaps even overarching privacy legislation, maybe to address other identifiable privacy harms. Congress may also wish to address the perception of harms, warranted or not, from a sense that the collection and use of data are too complex or simply go too far, which alone can influence marketplace behavior. The FTC has the dual mission of protecting consumers and fostering competition in broad sectors of the economy, and that includes primary responsibility for protecting consumer privacy. With those interests in mind, I think it is important that practices and conduct that harm consumers and that thwart innovation and competition in the marketplace are identified, analyzed, and if need be, regulated. Second, policymakers around the world are training their focus on privacy. Domestically, the potential proliferation of state privacy laws, like in California, will pose a host of challenges for companies large and small. Europe has not only adopted the General Data Protection Regulation, GDPR, but is using adequacy determinations and other tools to encourage other countries around the world to follow suit. Now, Europe and the US differ in how we have approached privacy regulation, reflecting different legal philosophies and different legal traditions, which lead to different privacy regimes and different trade-offs under them. The European approach begins with fundamental rights in data, whereas we in the US have looked to protect consumers from harm. I think it is crucial for the US to keep its foothold and maintain an active role in the international arena. Privacy legislation incorporating our traditional harm-focused, risk-based approach to privacy protection may be one way to do so. The what of privacy regulation is much more complicated. Privacy is a nebulous concept, and people differ as to whether and to what extent they experience a given kind of conduct as a violation of their privacy. Are privacy harms limited to physical injury and financial loss? Probably not. Do they include emotional distress? Is a sense of surveillance or creepiness characteristic of an eggshell plaintiff or something Congress needs to prevent? What about a lack of empowerment or a loss of control? And how, if at all, do all of these concepts take us back to Brandeis and Warren's famous articulation of the right to privacy, the right to be let alone? Our founders designed a Republican form of government to answer questions like these. As Justice Gorsuch reminded us last week, quote, "The Constitution promises that only the people's elected representatives may adopt new federal laws restricting liberty. Regulation restricts liberty, optimally only when the public good is advanced. And that is why I believe, and I have told Congress repeatedly, it is the legislature that needs to determine which harms need to be vindicated, because privacy legislation will necessarily involve important value judgments that should be left to Congress, not unelected commission officials. What harms we address, what rights consumers ought to have to address those wrongs are fundamental, non-delegable, democratic judgments. To be clear, that is not to say that the FTC doesn't have a role. Any legislation that Congress determines to enact should maintain our role as the nation's primary privacy enforcement agency. And Congress is not without important guidance, including from us. In considering whether and what to do, Congress will not be acting in a vacuum. Legislators can draw from our history and experience with our current risk-based privacy framework. Furthermore, the United States has already been working with our economic allies on privacy issues for decades. For instance, in the forms of the privacy frameworks of the OECD and APEC, the Asia-Pacific Economic Cooperation Forum. These can and should form a basis for discussion. Privacy legislation will involve trade-offs, in particular when it comes to innovation and competition. Large companies can more easily bear the costs of compliance, while smaller firms will face more risk and uncertainty. That means legislation carries the possibility of entrenching incumbents while limiting new market entrants who may provide competition and innovative, valuable products and services. We think about this on the other side at the FTC. This is an issue that I have spoken about before, and I've raised with Congress. There is already some evidence that since the implementation of GDPR, investment in startups in Europe is down, and more market share is flowing to the largest companies. Ultimately, time will tell about the impact. But to guard against these kinds of concerns, as Congress moves forward to regulate so much of the economy, it should take care and be cognizant about the impacts and trade-offs. This means moving cautiously and learning from our experience with US privacy laws enforced today and the experiences of jurisdictions that have instituted different privacy rules. In considering legislation, one area Congress should focus on is information asymmetry, helping ensure that consumers in particular, but other market actors too, have more and more accessible information on which to make informed decisions. One clear line we can draw to Brandeis is that sunlight is said to be the best of disinfectants, and better information can solve a host of problems. I also believe there's value in encouraging companies with large and complex data holdings and practices to engage in internal privacy assessments so that they better understand their own landscape and can make informed, risk-based decisions about how they gather, use, and share data. And for what it's worth, I think GDPR does offer some important concepts to consider. Take, for instance, determining democratically a set of legitimate data uses where companies are free to operate, where even consent is not necessary. That approach can be efficient and makes economic sense. When here's a lot of talk these days about rulemaking, penalty authority, preemption, and private rights of action, those are very important issues. But they are also secondary in the sense that they are mechanisms to effectuate the will of Congress, to apply it and to enforce it. So this process must first involve defining what the standard of liability should be, and then deciding how best to effectuate it. Which brings us to the how of privacy legislation. The first how is, as I mentioned, rulemaking. Rulemaking authority raises those important issues of delegation and democratic accountability that I mentioned earlier. Congress, not an administrative agency, is the best place to make policy with a profound impact on a substantial proportion of the economy. Congress should consider that the flexibility that rulemaking permits also allows for changes in rules over time. Think about net neutrality, which, regardless of the underlying policy, can be terrifically difficult for businesses attempting to adapt. A better strategy is to draft statutes that provide guidance on rulemaking to ensure that the agencies effectuate congressional intent. Another how of privacy legislation is the consideration of a civil penalty framework. The privacy legislation Congress is now, or may now soon be considering, may address many privacy harms that not only result in little or no tangible harm to consumers, but also are really difficult to quantify. Penalties can provide an important deterrent for bad conduct, but improperly calibrated penalties can deter companies from exploring innovative and consumer-friendly products and services. The risk may simply be too great. Frankly, even properly calibrated enforcement can still impose costs. To account for this, any penalty scheme set by Congress should be built around the harms that Congress defines and balance a range of factors, including consumer harm, and be set on a graduated scale so as to tether them to a coherent set of principles laid out by Congress. A substantial body of economic literature supports the consideration of harm in the fashioning of penalties, and common sense as well dictates that which threatens, that we penalize more, that which threatens more harm. Furthermore, even if Congress is to impose penalties for initial violations, that scheme need not apply to every violation. Civil penalties could be foregone in the first instance for some conduct, particularly conduct the legality of which is more difficult to determine in the abstract or ex ante, and the deterrence of which may have negative consequences. Penalties make more sense with clear rules. Preemption is another aspect of the how of privacy legislation. Application of a single legal framework across the country provides consistency and fairness. Allowing different states to apply different laws, the content of which we do not and cannot yet know, could result in different regimes in different states, and accordingly, radically different goods and services offered by technology companies. Researchers have found that state-level privacy laws built on top of a federal floor of regulation have deterred the pro-consumer potential of electronic medical records. So that's HIPAA, which is one of these federal floor with state laws built on top of it schemes. A patchwork of different regulations will favor large national firms and disproportionately hurt smaller operators, many of which may be local. In some cases, technology companies may choose not to provide certain services to citizens of some states because of the undue legal and financial risks a particular state's laws might impose. A single federal law could help avoid such outcomes and ensure that consumers across the country are treated fairly and equally. Where we have a variety of differing state laws, the FTC will have to engage in competing investigations and lawsuits with state law enforcement agencies, rather than more efficient collaboration. And the result will be less federal-state cooperation, more protracted investigations, more complicated litigation, and more challenging settlement environments. We may also face situations where similar, yet distinct, laws are subject to different legal interpretations by courts, removing some of the Commission's power to shape consistency in that interpretation through our own case selection and legal arguments in federal court. Let me finish with two final points. First, attorneys general can be important partners in protecting consumers, acting as force multipliers for federal law enforcement. I think Congress should consider them. It should also consider, however, whether to allow the FTC authority to assert exclusive jurisdiction where necessary to ensure consistent and coherent application of federal law. Second, data collection and use are endemic to our economy, and they are the engines of significant economic growth and consumer benefit. Any federal privacy bill will thus apply to a vast array of companies, large and small. A private right of action will have a substantial and unwarranted negative impact, particularly on small, innovative businesses, deterring them from innovating and growing jobs as they prioritize lawsuit avoidance over doing what they do best. Any new federal privacy law must provide for rules and regulation, but it should do so in a way that best permits for future growth and innovation, and that encourages investment and risk-taking. Government enforcement of a privacy law, rather than private lawsuits, is the best way to balance those interests. My remarks today highlight the work ahead of us on privacy legislation, and I realize that it will be difficult and challenging. However, these are the kinds of difficult and challenging decisions that we must get right, because there is so much at stake. Thank you all for the time today, and I look forward to taking any questions that you have.
Thank you very much, Noah. We appreciate that. So you notice he said he looks forward to taking any questions you have. What we're going to do is have to limit it, I think, just to 2 or 3 because of the program. But if you have questions, a couple of questions, we can do it. And if there are those at the press, if anyone has one, I'll turn to you. If not, anyone have a question? Right here, Deborah. We're going to give you a mic real quick. And you could just identify yourself. And Noah, I think that mic works.
My name is my name is Deborah Lathan. He knows me as from the Big Red School. Yeah, Michael, you just spoke about how necessary this is for the economy and how money and things are being generated. There's been much discussion about whether or not these big companies should pay consumers for their data. And so I'd just like to get your view as to whether or not companies should actually pay consumers.
My short answer is I haven't yet seen a scheme that would make any kind of sense. The sort of grand bargain that we've drawn thus far is that many products and services are provided to consumers for free, and data that are collected in those transactions with consumers are used to monetize, right? And on some level to provide those services for free. There are some real important questions, I think, about the degree to which consumers understand that transaction. And that is part of why one of the things that I called for today is thinking about how to address that information asymmetry. But I don't think, I mean, I certainly haven't seen a workable or desirable scheme where you would like have cash payment. I don't know how you would do that. I also am not sure that that would, it would sort of further economic growth. Again, I haven't studied that in depth, but I haven't yet seen a scheme that makes sense to me in terms of that.
Okay, got time for one more question if we have one. Kelsey, you get the mic in just a second.
Hi, Commissioner. You mentioned that state AGs can be helpful partners and Congress should be thinking about how to include that in any legislation. What do you think that would look like?
So I think this is one of the important questions they need to consider. If you think about the scope of what privacy law or any large privacy law will involve, no matter what kind of resource allocation you do at the FTC, it's going to apply to a lot of companies in the economy. And so I think Congress, as I said, really should consider the role of state AGs. The one additional point I would make is that there is a value when we have some legal regimes, or at least I understand we have some legal regimes that work this way, in allowing us to sort of come in and take a case to make sure that the application of a national law is consistent. That consistency is really important for predictability in the market. It's important for consumers who we want to understand what the rules of the road are. It's important for firms who we also want to understand what the rules of the road are, which is part of the reason I really believe Congress ought to preempt state laws.
Okay, Commissioner Phillips, thank you so much for that thoughtful and comprehensive speech. It really gets us off to a great start today, and I'm grateful. One of the things we do to show our appreciation at Free State Foundation events is we try to have a small token of our appreciation where you'll stand up for this one. Come on. You know, to be honest with you, we're getting close to the end of running out of things to slap FSF or Free State Foundation on. You know, we've done a lot, but and we don't like to be cheesy about it either. But what we have today is a cheese board. Got a cheese board, and it's got a little FSF on here, and it's just it's a small token of our appreciation. I want everyone to join me in thanking Commissioner Phillips for that.
Thank you very much. Thanks, everyone.
Okay, I want to call up our panel right now, please, and we're going to have to proceed right to them.
Thank you for joining us today. We are now at the panel portion of our event on privacy regulation, why, what, and when. I will be introducing our panelists. First and foremost, we have Kelly Cole is the Senior Vice President, Government Affairs at CTIA, where she oversees CTIA's Hill team in advancing the wireless industry's priorities before Congress. That includes issues not only such as privacy, but certainly spectrum policy, 5G infrastructure deployment, combating robocalls, and any other number of issues. We also have with us, and we're delighted to have Michelle Richardson. She is the Director of the Privacy and Data Project at the Center for Democracy and Technology, where she leads CDT's efforts to create a user-centered internet. Her team engages companies and government officials to create policies and technical solutions that protect individual privacy, empower users, and advance social justice. Next we have Lynn Follansbee. She is the Vice President of Law and Policy at USTelecom. She provides policy analysis and legal and regulatory support to USTelecom and its members on a range of issues, including privacy, consumer protection, universal service, and mapping. And she represents USTelecom and its members before the FTC, FCC, and other federal agencies. And we also have with us today Loretta Polk. She is the Vice President and Deputy General Counsel at NCTA, the Internet and Television Association, where she leads NCTA's privacy and cybersecurity, legal and policy work. She has represented the cable industry on a wide variety of legal and policy regulatory matters, including consumer protection, video and broadband technology, competition, and public safety. So how we're going to conduct this panel is each of the panelists are going to speak for up to 5 minutes with some initial remarks on our topic today about internet privacy regulation. I'll give the panelists at the end of that time an opportunity to respond to each other if they so wish. We'll then give some questions to the panel, and if we have time, we'll get some questions from the audience as well before we move into the closing keynote address. So I'll just start with, we'll just go down the line, and I'll start with Kelly Cole from CTIA.
All right, thank you very much. And a huge thank you to Randy and Seth. Thank you for inviting me here today, and to the Free State Foundation. And I'm thrilled to see a lineup of 3 other very talented women. So love it when that works out. So I guess when I sat down and started thinking about this topic in sort of a little more of a granular way, there obviously seems to be consensus among policymakers, consumers, and industry that in sort of what is turning into be a very data-driven world, that we need to provide more control to consumers over their personal information. And CTIA and our membership very much support a comprehensive, technology-neutral federal privacy law that's enforced by the FTC. There is no doubt that there are a lot of benefits from sharing data. You know, I can get an Uber wherever I am, on wherever corner I may find myself. I love the fact that I can save money on my groceries with a loyalty program. But we all need to recognize that the sharing of that data needs to be done carefully and needs to be done appropriately. Or people, frankly, like me, are going to turn away from a lot of new technologies that ultimately will benefit consumers. So a big part of what's driving this debate inside of CTIA is really the importance of consumer trust. And obviously, our networks at CTIA, we represent the wireless carriers, we represent the phone manufacturers, and the folks that make the guts of a mobile phone. We're in the business of providing an infrastructure that allows people to share that data. So we have every incentive to develop strong and robust privacy rules that ensure our customers come back to us. And we just released over at CTIA the 2019 Annual Wireless Industry Survey, which I thought provided some really interesting sort of data nuggets for why this is becoming increasingly more important for every industry, but in particular CTIA's membership. Wireless demand is growing at an incredibly staggering rate, and these numbers frankly caught me by surprise. Americans used 82% more mobile data in 2018 than they did in 2017. I mean, that blew me away. 28.5 trillion megabytes of mobile data in 2018. And of course, you layer on top of that the fact that everything is connecting to everything else. So this whole notion of the Internet of Things just makes this conversation increasingly more important. So the consumer trust angle is something we take very seriously and we view as very critical. And there's no doubt that consumers care about this issue. I'm sure many of you saw there was a Morning Consult poll that came out in May of this year. 83% of consumers expressed support for a new privacy law, and 73% of those say they strongly believe that data privacy protections should not depend on where they live, which for certainly my members and my association is critical to this overall debate. I actually drove across the country over Memorial Day recess, went through 11 different states, and You know, whether I was on Facebook driving in between Oregon and Utah, or on Amazon buying something between Florida and Georgia, I think it's only fair that as consumers, they know what the rules are. And it's completely unfair to consumers to have a patchwork regime of up to 50 different state laws that don't protect the same way and provide sort of expectations for privacy that should be expected. So as we all know, the internet does not respect state boundaries. That's just not how it works. And so it's obvious to CTIA and our members that we need a national privacy regime. So really, I come to this as our chief lobbyist over at CTIA. I spent a lot of time on this issue on Capitol Hill. And so I really look at this through the lens of what is Congress going to do. And I'm hopeful, certainly hopeful, that we get a law this year out of the House and the Senate. The Senate's obviously been spending a lot of time on this issue. There's a gang of 6, recently added Senator Thune and Senator Cantwell to that mix. They're having discussions, but this has been going on for months. These negotiations have been happening for months, which I think just underlines how difficult this issue is. It is hard, it is dense, it can be emotional. So there's a lot of things that still need to be resolved, but again, I'm very hopeful that we can get a product out of the Senate that can hopefully pass the House. And obviously our goal would be to see that language and legislation passed by 2020 before we have to deal with California law coming into effect. So I think that's probably my 5 minutes, so I'm going to hand it over.
Thank you. Michelle Richardson, Center for Democracy and Technology.
Yeah, thank you. We're very excited about the unique opportunity we're facing right now and the possibility for a federal privacy law. I understand this comes up every 5 years or so, but this time it feels different. And I would say it's because we know more than ever about how technology works. And you can see the learning curve on consumers collapse in real time, right? And it's partly from great journalism, academic research, and people now understand what's at stake with this data, right? You can't say, well, just get off Facebook if you don't like Facebook. We've now come to realize that everything is connected. Our cars, our homes, our children's schools, right? Our workplaces, and there's no way to opt out of data collection anymore. It has brought us great benefit, but it's time to start dealing with and minimizing some of the risks that it has brought into our lives. And this means rebalancing power between companies and consumers. We are woefully out of whack, and this is because we have sat out the development of privacy law for so long. While we have our sectoral laws like banking and healthcare, for example, those now have to represent a tiny fraction of the data that is created and out there about us and used in ways to make very important decisions about us every single day. So what would be the principles of what legislation should look like? One, everybody should be treated the same. I think there are questions about banking and health staying where they are, but everyone else, whether you're a brick and mortar store, a telecom, or a big tech company, we need one set of rules here. We have to move past chunking up the different pieces of our economy because it doesn't really matter anymore. The data is so fluid, and it really doesn't matter who holds it. We need to shift the burden to companies. Like I said, we're in an always-on society, and there is no way for individuals to understand and manage all the different relationships they have with companies. When my boss testified recently, we tried to quantify what it means to be out and online in the world, and we looked at her phone, and she has 260 apps on it, right? That's just her phone. That's not her laptop at home or her work laptop or her Amazon or her connected car or her Fitbit. She's a tech enthusiast. When you add up all of those different devices and accounts, there are hundreds, if not thousands, of companies touching her data and your data every single day. There is no way for any of us to micromanage those relationships, even if you're the smartest person who understands how all of this works. We would like to see clean lines, too. We understand there needs to maybe be some play in a statute that allows for innovation or advertising, but the most important thing we can do here is set some clear lines and boundaries about what's inappropriate. We now know what types of data use lead to exploitive, abusive, or privacy violations, and we just need to be clear about that. And I would agree with the commissioner that that is Congress's job to actually draw those very clear lines. And finally, we have to just get at the issue of collection, sharing, and use of data. I think that probably sounds silly, but by the time you talk about all the other issues out there, you realize you never actually got around to the privacy part of the privacy law, which is what are the rules for collection, use, and sharing of data, right? And I think we are maybe a little too negative about what's possible. There are huge advancements in technology now and ways to process data in privacy protective ways. It is not impossible. So if we have large companies who are going to do very advanced data processing, we should expect very advanced privacy policies from them. I can get into more detail later, but I will just say, also, I would say beware of sideshow issues. It's going to be controversial. One, transparency. I think a lot of people want to start with transparency. Just tell people what happens with their data, right? I don't want you to tell me what you're doing. I don't want you to ask me. I just want you to stop doing things that are exploitive or violating privacy, right? That's the entire point of the law. We are in a unique situation where we need our government to negotiate a better deal for us. There's nothing that we as individuals can do this, no matter how much information we have. And two, we need to move away from user responsibility. We need to make it much easier for what people understand on the surface products to be enforced. So for example, when I use Google Maps, I understand it's going to track my location, right? That's the whole point of it. I don't know that some silly game I put on my phone for my child is surreptitiously collecting it solely for the purpose of selling it, right? We have to limit those secondary uses that are not apparent on its face. And I think we want to move away from the model of data as something you own and that you should be paid for. This has gotten more traction over the last few months. I really didn't expect it to, but I think we have to be realistic that, again, that doesn't affect the collection, use, and sharing of your personal data. And I think people would be shocked to find out how little their data is actually worth. There was a great story in the New York Times about precise geolocation tracking from your cell phone. And apps who are collecting it and selling it on the open market get about 10 cents to 25 cents a year per user, right? So who's going to take the time to go get their 2 cents for the location data from the hundreds of different companies who have it? It's not going to be a way to actually change systemically how this works.
Thank you. Now we'll move to Lynn Follansbee, USTelecom.
Hi, thanks for having me here today. Just for those of you who may not know, USTelecom represents broadband providers. Our association was traditionally the old wireline telephone companies, but we are now broadband providers and internet service providers. So that is where we come from. Our association also represents not only the biggest broadband providers, but also some of the very smallest rural providers throughout the country, sometimes, you know, just as small as serving one town. So this privacy issue is important not just to some of our biggest members, but also to our smallest, because quite frankly, when there's regulation in this space, the impact has to be considered down to the very smallest provider, not just what the big companies have to understand. So, USTelecom, we support the adoption of a strong national privacy framework governing all the stakeholders in the internet ecosystem. As other folks have said, we think it's really important to balance the need for strong, clear protections for all American consumers with an approach that continues to allow for unparalleled innovation that has driven the internet economy to where we are today. Our companies have always put a priority on their consumers, and I know going back to just a few years ago, 2017, our multiple associations had reaffirmed their commitment to the FTC policies on transparency, consumer choice, data security, data notification. And we have a longstanding set of principles that we abide by, have always abided by, and continue to abide by up until today, even in the midst of this giant debate that we're having. The need for federal legislation that establishes a strong national privacy law will make it easier for consumers across the country. It'll be really clear for them. And this existing and expanding patchwork of state and sectoral specific federal privacy, patchwork of state privacy laws is only creating a fragmentation in the protections and resulting in inconsistent protections for consumers. National privacy legislation that preempts state privacy laws would avoid this patchwork and provide a really consistent, clear way for consumers to navigate this space. Additionally, we believe that legislation would serve as a good opportunity to further clarify and enhance the FTC's role to police privacy practices and protect consumers, and while at the same time preventing inconsistent regulations and helping to expand innovation.
Thank you. And Loretta, Polk, NCTA.
Great, thanks, Seth. I guess the beauty of going last is that I can say there's a lot of commonality among the speakers here at the table. There's broad alignment around a lot of the issues in the privacy debate. And as we heard from Commissioner Phillips, there are forces in Washington and abroad that are driving action toward privacy, and we may finally see, after years of working on this issue, we may see Congress move forward. And then all of this is sort of combined with the FTC's ongoing examination of competition and consumer protection policy in the 21st century. And this is all intensified, in our view, the need for Congress to comprehensively address privacy at the federal level. For over 30 years, cable operators have taken steps to ensure the privacy of their cable television subscribers in accordance with strong protections enacted by Congress. And cable as a broadband provider similarly has been guided by the key principles that embody the FTC's privacy framework that's been developed over several decades. The privacy protection measures taken by cable companies reflect not only federal policy and law, but a business imperative to strengthen customers' trust, as we heard earlier, and by showing that we are responsible stewards of our customers' personal data. But with the online abuses that have come to light in recent years, it's time, we think, for lawmakers to go a step further and codify strong and enforceable consumer privacy protections for the internet. We, like others, support establishing a uniform, technology, and competitively neutral national policy for privacy that protects consumers from harmful misuse of their data, but also allows for innovative new services. We think broadly applicable national standards would serve the important interests of protecting consumers and promoting responsible data uses and innovation in the digital age. This means that consumers should have meaningful transparency, choice, control of their data, security, and with respect to how it's handled, regardless of where they are or what product or service they're using. Consumers should also have reasonable rights to access, delete, and correct their data. And federal privacy standards should be flexible and agile enough to allow for changes in technology and business models. The federal framework should be built on FTC authority to continue to enforce violations, and where lacking, the law should provide the agency with necessary resources and authority to be optimally effective. Regulatory parity, that is a very important issue for our companies. It's critical in a vibrant and dynamic segment of the economy to ensure that market forces and consumer preferences dictate marketplace outcomes. Parity ensures that consumers are afforded consistent privacy protection as they navigate the digital marketplace, regardless of the identity of the entity they're interacting with and the service they're using, or the nature of the technology employed. As we've heard throughout the day so far, the potential for national fragmentation of privacy policy and regulation from the emerging patchwork of state laws has heightened the importance and urgency of enacting a single national policy related to privacy in the US. Companies' day-to-day practices in the management of data would need to vary state by state, where network infrastructure and systems and the internet itself are borderless. A patchwork of state and local laws imposing diverse obligations on how companies collect, use, and share data will only confuse and disrupt the consumer's online experience and also potentially impose disparate, costly burdens on businesses. Consumers will benefit from the predictability and consistency of a uniform national privacy policy over conflicting state-by-state regimes. So a few more points. While only Congress has the authority to comprehensively establish a single national privacy framework administered and enforced by the FTC, which preempts state law, the FTC, as the nation's lead privacy enforcer, has an important role to play going forward. The Commission can continue, under its existing authorities, to make progress on privacy policy and guidance in tandem with legislative efforts in Congress. Indeed, the work the Commission does now in advancing a national privacy framework can help shape the approach taken by Congress. The FTC's longstanding privacy framework continues to work effectively to balance the various goals on both the consumer and business side. But as the Commission revisits consumer protection in the 21st century, we think it should look to refine its framework in light of recent developments and emerging issues. This might include strengthening mechanisms for safeguarding consumers against unexpected access or use of their data by third parties, improving or supplementing the notice and choice model to provide consumers with additional privacy protection, promoting the use of effective de-identification techniques and controls, and identifying harms that the Commission's privacy framework should address. It also should look at adapting its framework with respect to new areas around artificial intelligence and algorithmic discrimination. So in sum, there's broad support for baseline privacy legislation. The challenge, as we've heard, is translating widely agreed upon principles into a substantive legal framework in a complex area. The cable industry is committed to working with government and stakeholders to meet this challenge and to enact a comprehensive national privacy law that provides consumers and companies alike with a consistent set of rights and obligations that both strengthen privacy protection and advance competition and innovation.
Thank you, Loretta. Thank you to all the panelists. Is there anyone who has a response they want to give to anything else that they've heard to this point? Okay. Well, I'll jump right in with some questions here, and I'll direct this first one to you, Kelly. And in terms of, you work on the Hill, is there any kind of legislation in Congress that you see on the horizon? I mean, you mentioned a Senate gang of 6. Do you have any more meat to put on those bones, or anything that's kind of cohering or sense of where that's going?
Oh, I wish I did.
Okay.
No, there's a lot of bills, frankly, floating around Capitol Hill right now. It's the issue du jour. Everybody wants to get in the game on privacy. I think the sort of bipartisan gang of 6 that we've seen is probably the farthest along in doing the work in a thoughtful, meaningful way. And the fact that it is bipartisan, and you literally have members from, Senator Wicker to Senator Blumenthal, you've really got the spectrum of ideology there, and they're all sitting down, sort of working through these issues. I think just this morning I read that Senator Wicker would not make a commitment that we would see a bill before the August recess. So, like I said, these are very difficult, dense issues. I think the good news is that they're actually talking about what we would hope would be discussed sort of towards the end of the process. And things like private right of action, state preemption, some of these really big, thorny, meaty issues that are frankly going to take some time, but I'm hoping that means, to Michelle's point earlier, that they've sort of dealt with the true privacy issues, and they're sort of hashing out those final remaining really controversial issues. That's my hope.
Well, Michelle, you talked about having Congress set clear lines and boundaries, certain things that they shouldn't, you don't even have, it's separate from consumer consent, certain things, certain uses of data that are just harmful to consumers and they just shouldn't be doing those kinds of things. Could you give some examples of things Congress should consider as being beyond those boundaries?
Yeah, and I think there are two things that we often focus on at CDT. One is discrimination, and this is not price discrimination, but that the data is being used and processed constantly in ways that make decisions about people. And this could be big stuff like mortgage rates, right? The advertisements you see for educational institutions, or it can be small things too, but that we need to be more aggressive in making sure that because all this is so opaque and hard to track, that it isn't obscuring things we don't want to happen. The second thing, though, is we are really leaning hard on limiting secondary uses. I think what we find in FTC enforcement and talking to people, and even people at small businesses, you know, if you're offering the actual service someone requested, they are very forgiving. They understand there is a universe of things that has to happen with their data. But it's always that secondary use where it is something wholly unrelated that offends people, and that's where it's also the most dangerous, right? Because it's usually going to someone who doesn't even have a relationship with the person. Frankly, what do they care? You know, it's no one's going to hold them accountable. It's hard to track this. So we would say those are two areas where you can do clear lines, and we know that makes people uncomfortable, right? But I think it will benefit small businesses, consumers, enforcers to work on a smaller list of activities or data sets and make clearer rules.
Okay. Loretta, you were talking about all the panelists really to some degree or other, about the issue of patchwork and state regulation and the conflicts that would pose. And there seemed to be, I don't want to be imposing things on the panel, it seemed to be a consensus that we need to have some kind of national standard. Now, the FTC held a hearing on June 12th that featured state AGs and state officials, and I would say there seemed to be a consensus going in a very different direction. I remember one state official saying that simply having multiple privacy regimes doesn't by itself make things impractical, and that talk of harmonization among privacy regimes would create a lowest common denominator approach. That's a very different viewpoint. Do you have any response to these kind of arguments from the state side against preemption?
Well, first of all, I think we'd fundamentally disagree with the premise that harmonization means that a privacy policy at the national level is going to be weak. I mean, I think everyone at the table here and all of us working on this would like to see a comprehensive law that gives consumers significant rights going forward with respect to the use, collection, and sharing and disclosure of their data. So I don't think it necessarily means there's a rush to the bottom here in terms of a national level. I do think state AGs have a role, and I think should be given the opportunity to stand in the shoes of the FTC where it's appropriate to bring a lawsuit in a state where their citizens have been affected by the national law. But of course the FTC would have the overriding authority there to step in if needed, but I think state AGs have an important role going forward, but we still believe that, you know, preemption of state individual privacy laws is sort of critical going forward given the potential adverse effects of a patchwork.
All right, thank you. Lynn, during your talk, you discussed a national framework, and as part of that, an enhancement of the FTC's authority and its role. How can an overarching privacy statute that could be very broad, that may have rulemaking authority, how can that address something in a way that doesn't give too much power, too much discretion to the FTC? That, I mean, because a lot of, as we heard from the commissioner this morning, a lot of consumers have very different expectations and things, how they want to use data. How can you control for something like that in legislation that touches on FTC authority?
Well, I think that the key, and I think Commissioner Phillips touched upon this, is that if the FTC has some limited rulemaking authority, it could potentially help down the line so that we're not back revisiting this issue in a few years. you know, we're talking about trying to balance the need for consumer protection, but also allow for innovation. I mean, the internet where it is today is because there have been great innovators and have expanded it to all these cool things that you and I get to do over the internet. I mean, I don't think I go to a department store anymore. You know, I'm an Amazon addict. So, and that's something that I think is a really great part about the internet. So I think if you can carefully walk that line by giving the FTC some limited rulemaking authority in order to allow for changes as we move over time, and there's new innovative ways for the internet ecosystem to grow, and you know, use rulemaking to sort of help work through it as it changes.
Okay.
And additionally, let me just say also, I think we're very supportive of giving the FTC some additional resources because, I mean, right now, I think there's about 40 people that work in their privacy office. And if you think about the largesse of this issue, there should be way more than 40 people working on privacy.
Now, Michelle, when the Commissioner Phillips spoke today, he mentioned private rights of action, civil penalties or FTC authority to impose civil penalties for first-time violators. Do you have any views on those particular kinds of remedies?
Sure. Well, I will add to something on private right of action. I think people are oversimplifying it, right? We have people saying we want to be able to sue over everything, and others saying we want to sue over nothing. And there are a million options in between. And the reality is right now there is a right to sue in all 50 states. Taking that away from consumers is a big change. It is a serious decision to tell people they are not allowed to access an entire branch of government. That's what people are suggesting, right? I mean, that's a big deal. So we should be talking about, is there some set of harms that we think are so important or are better served by individual litigation? And so I would point to, when I say the 50 states, they have many FTC acts, right? They have their unfair or deceptive practices too, and that's how they do these privacy enforcement. You can look at them and they are very diverse. Some ban class actions, some have a very limited harm standard, some don't allow, you know, recuperating fees. There's just so many options here that we should be talking about to make sure that consumers can be protected. Because I think even if you got the FTC, right, you have your state AGs, there are going to be violations that only impact a small group of people or an individual, right? If something happens to your data, do you expect the FTC to actually sue for you? Not going to happen, right? So if we are going to preempt all these state laws, we need to be realistic about how we make sure users can be empowered to protect their own interest in some situations.
Okay. Kelly, I want to take it back to you. Getting back to the Hill in legislation, so there isn't a lot out there yet, but could you, at least from the standpoint of what are the things that you really don't want to see come in any privacy legislation?
Private right of action. Yeah, that would definitely be on the list. And I do sort of look at this in sort of the opposite frame. Like, what do we need to have in there? And I think we would include things like, you know, state preemption. I think is really, really important when you talk about, again, creating a potential patchwork of 50+ regimes. That's just not something a consumer is going to be able to manage, and it starts not to mean anything. So we need it to be technology neutral. To the point that was made earlier, we believe everybody should be treated the same under this regime. And really important to the sectoral sort of point, we want to make sure we don't have multiple regulators. Really, the FTC is the right place to house this authority. They have the expertise. They've already brought over 500 privacy-related actions. Like, they know what they're doing. Let's put them in charge. And then I think on the rulemaking piece, we're not against, again, a limited rule for rulemaking. We just want to make sure it's actually limited. And I think the commissioner made a perfect point. You know, we don't want this to turn into a net neutrality debate where every 4 years or every 8 years we're seeing these massive swings, which gives no consistency, no predictability to consumers or to industry in how to provide these protections to consumers.
Well, thank you. I'd like to direct another question to Loretta. Now, the FCC, the Federal Communications Commission, does have a kind of narrow slice of privacy jurisdiction that has to do with, and yeah, this could easily go to Lynn as well. I'd be interested in your take as well. It has to do with CPNI, CPNI. All right, customer proprietary network information. That's the subscriber information that voice telephone providers, cable providers, DBS providers have, or they receive from their subscribers, and that the FCC has authority over their collection and use of that subscriber information. So if we've got that out there, that FCC authority, and we're looking at an overall national framework, where does the CPNI go? Does that stay where it's historically been at the FCC, or does that get folded into the FTC or whatever agency takes over? Do you have a position on CPNI?
Well, of course, the FCC reinstated the reclassification of broadband providers as information service providers, not telecommunications providers. So that affects the applicability of Section 222. We'd argue that Section 222, was written in a telephone-centric context, and the legislative history, the statute itself, all of the rules under it, relate to traditional telephone service, and so, we've argued that it's not a basis for, regulating in the privacy area. So I don't know if Lynn wants to elaborate.
Yeah, I think that's exactly it, is that the CPNI rules were written a long time ago with respect to telephone service, and where we are now with, internet service, broadband service, is so much larger than what's encapsulated in the CPNI rules. So I think that, we've argued, and obviously when the FCC attempted to take jurisdiction, back when the net neutrality rules were that broadband was under Title II, we've definitely fought that and said, absolutely not, we think it's information service. And so fortunately right now, currently the FTC has the authority, and we think that really is the best place. The reality is, even when the FCC had Title II authority over our companies in this, we argued that the FCC really did not have the kind of expertise that the FTC has, as we've talked about up here. The FTC has a long history with their FIPS, and they've just been doing this a long time. They've spent a lot of time in this space, and we think it's really the appropriate place.
Well, Kelly, let me follow up and ask you about that. When we had the FCC had for a very limited time asserted its jurisdiction in the privacy sphere in a much bigger way. Congress later repealed its regulation. Is that something that you're having to push back against at this point in terms of the internet privacy issue today? Are all sides pretty much willing to say, okay, we can keep that separate, we can keep the net neutrality stuff out of this? Is that a debate that's still happening?
Not so much in the privacy space. Yeah, occasionally you hear the argument about the privacy CRA, and sort of from a political perspective, not necessarily from a policy perspective. So I do think, I'm hopeful at least, they're separated enough that we can truly have a privacy debate and focus on the FTC. And I would just echo everything that Lynn and Loretta just said. From CTIA's perspective, we don't think that sectoral laws as they relate to CPNI make sense anymore. We've sort of moved beyond that. And if you're going to do this, again, we don't want dual regulation. If we're going to do this, let's do this right, and let's house that jurisdiction at the FTC, where, frankly, it makes the most sense.
All right. Michelle, there was a 2017 survey by NCTA, and it said that Americans' #1 fear in going online was identity theft or identity fraud. And that's kind of a different set of harms than we're mostly been talking about here. We've mostly been talking about commercial uses and collection of data and sharing it and selling it. But there's a little bit more of a bad actor element here involved, of course, with that. That's sort of equally data security as well as data privacy. Do you support federal legislation that would deal with data security in particular and those kinds of ID fraud issues, or perhaps data breach notification, those kinds of issues? Should that be part of this, or is this kind of, view that as a separate thing? I'd just be interested in your whole take.
Yeah, and you know, we have a model bill on CDT's website, and we did include data security. We think it's time to level up and have a federal standard that everyone take reasonable efforts to protect data. Understanding that reasonable is very different depending on the type of data you have, how you use it, the size of your operation, right? These are the rules that the FTC has actually had out for years. This is consistent with international standards and where the states are going already. We think this should be not controversial, and there's a lot more agreement around data security than there is around privacy. So I think we were a little disheartened to hear that there are rumors of, you know, the first draft of the Senate bill may not have data security in it. And so if there are any decision makers listening, we would strongly urge them to include data security. This all needs to happen at one time. But breach notification, let it go. The moment passed. Like, I don't know how many ways to say. You know, it was 15 years, never happened. There's now data breach in all 50 states, just let it go. It's a very different issue from the substantive data security, so it can be severed. And frankly, it's not as important as actually saying take reasonable efforts to secure data, right? That could lead to systemic change and better practices. I think people are disappointed with how data breaches turned out. We thought it was going to cause reputational harm to companies that would allow consumers to vote with their feet, right? And it would change behavior, and it hasn't. So focus on the data security, actual standards, let the breach notification go. The moment has passed, and we're happy to support people as they try to draft the data security section.
Yes, Loretta.
Yeah, I was just going to add that, you know, we think that it's important to codify the FTC's reasonable data security measures work in any statute that comes out.
Okay. Lynn, we'll stick with the FTC for a minute. I mean, if I think of like a typical FTC enforcement process, it's a complaint served by the FTC. It goes before even the commission, and if the result isn't favorable to the party that's the defendant, they could appeal to a court of appeals. Is that kind of process, will that work? I mean, is that kind of scalable if it takes on something as big as internet privacy? Well, is that where the rulemaking comes in and that alters things? I mean, do you have a view about that? I mean, that's probably more of an insider FTC question, but institutionally, but.
Well, yeah, no, I think that the FTC, if they have some limited rulemaking authority, I think it would probably enable easier enforcement. You know, if there's a complaint to the FTC and they have rulemaking authority and there's some clear rules, then I think it's much easier to bring an enforcement case. So we would support that. Okay, now looming in the background, Kelly, that you had mentioned the California privacy law. I mean, do you have a sort of a view or critique of that law? I mean, is it in terms of, if that were the national standard, would that be okay? Is the problem that is coming from the state level? I mean,
yeah, we have some real concerns with the California law, and I think, you know, this was a law that was literally pulled together in days. I mean, it's taken months, literally, for the Gang of Six just to sort of work through the issues that they've been working through in the Senate. So to think that you could sort of throw something together like that in literally hours, I think is just completely unrealistic. So there, you know, there are definitional problems in that law that, frankly, we're working very hard to see if we can get fixed. And there's, you know, an effort by industry across the board to see what we can do to make improvements to that. But I would certainly not recommend that Congress, the U.S. Congress, start with that as its base.
Lynn, did you have a view on the California law?
No, I think I agree absolutely with.
Okay, Maine has one as well recently. Okay. Okay, well, we're getting near the end of all of my questions and all of our time. So I'm interested in seeing if anyone from the audience, I've got 2 minutes, is interested in answering or offering a question. Not answering, but offering. And I see someone in the back there.
Hello, Richard Morrison with the Competitive Enterprise Institute. I wanted just for any of the panelists, if we do see a big comprehensive privacy bill come out of Congress like we're imagining, that polices the digital privacy policies of for-profit companies, should a bill like that also include aspects that police the digital privacy of government employees and government agencies as well? should they be subject to the same standard, I guess?
I would argue no, and I say this actually as someone who spent a lot of time on law enforcement and intelligence issues. It's just such different equities, and the consumer issues are so hard to sort out. I think if you add on employee, law enforcement use, and other things, it will fall under its own weight.
Okay, looks like we have one other question right over here. Microphone's coming. Yeah, and please identify yourself when you ask the question.
Hi, my name is Will Rao. I'm an intern at Comcast. So it seems like all the panelists agree that it would be somewhat harmful if states were passing their own privacy legislation because they could contradict one another or confuse consumers. But in terms of national legislation, it seems like there's a lot of gridlock right now. And so do you think that states have an obligation to pass their own data privacy laws simply to protect people while they're waiting for a more national one to pass? Or should states simply just wait?
Okay, good. Well, I'll point out that most of the state legislatures are winding now, right? And no other state was able to pass a comprehensive law this year. So the patchwork is still a year or two away, maybe. I think what you'll see in the meantime are maybe biometrics laws. Those are still hot right now for states who aren't ready for the big picture, or Maine with the ISPs, right? And you're going to continue to see people dabble regardless, whether they should or not. Hopefully that will inspire Congress to move faster, right? There's nothing you can do to stop them in the meantime. And I think as a privacy advocate, we're really torn, right? Like, what if this takes 5 years? We can't wait 5 years for privacy protections. We're going to be on a different internet in 5 years.
All right, well, that will conclude the questions today. I would like to thank all of the panelists, and please give a round of applause. Each panelist, as with the commissioner, will be presented with a cheese board from the Free State Foundation. Thank you.
Well, thank you.
Yeah, thank you, Kelly.
I love cheese.
Okay, well, now don't forget the Twitter handle, right? Hashtag FSF Privacy Seminar. And I think this is at Marsha Blackburn, I believe. Senator, you can see we have a full house here for you. I know I do have your bio, but I thought I memorized it. I know. Well, I was going to say, actually, my first words were going to be welcome back, because we've been privileged over our 13 years of existence, the Free State Foundation, to have now Senator Blackburn speak to us, I think 5 or 6 times, actually. And I went back and looked, and you actually spoke at our 5th anniversary luncheon, and again at our 10th anniversary. So I'd like to get a commitment now that you'll speak at our 15th anniversary. I don't have the date exactly in mind, but keep the year in mind. But we're now in our lucky 13th year. And we're really pleased to have you back. So what I'm going to do, there's the Senator Blackburn has a long bio and resume with more important things than I could hope to get to in one day. So I'm just going to do it this way, and you've got some of her bio in your biographical material there. But the important things are that Senator Blackburn is. It's really nice to be able to say Senator Blackburn after those. After those, we can say that's great. After the Congressman Blackburn, the important things are she's a member of the Senate Commerce Committee and the Senate Judiciary Committee, two very important committees that happen to deal with a lot of the issues that we talk about at the Free State Foundation, and previously when she was in the House, she served on the House Commerce Committee and headed up the House Telecom Committee. So I'm going to leave it at that and welcome Senator Blackburn.
Thank you, Randy. And yes, indeed, I am so happy to be back with you all. And on the 15th, when you get there, maybe I will be back talking with you about how we have implemented the privacy law and how we have practiced preemption and how beautifully it is working. So we're just going to keep channeling that thought and hope that we can push it there. Right, Counselor? Absolutely. That is so true. But yes, Comms and Tech, chairing that and working with many of you in this room. I will tell you this, I think the last time I spoke with you, we talked about the need to reauthorize the FCC and modernize it and get that done and make preparation for 5G. And in that role as chairman in the House, I was able to spearhead that reauthorization of the FCC for the first time since 1990. And then we rewrote the Mobile Now bill and put it into what became Ray-Baum's Act, and got the FCC reauthorized, got the access broadband, the precision agriculture, Mobile Now. I got it all done, sent it to the Senate, and they got it into a package, passed, signed into law, done. And we felt like that was a big achievement. It's important because when you look at this point in our society, we really have accepted the ubiquity of digital services. And I have to say, I kind of liked listening to this all-female panel. I talk about how important digital services are. You know, when you think about your transactional life, many of you are probably planning your 4th of July getaway right now, or you're ordering groceries and stocking the pantry, or you're doing any number of things. You are entering the next location that you're going to go to from here so you can navigate the traffic circles. And we just assume that this is going to be a part of our life. Now, I think what many people have realized, what a lot of consumers have realized from the first time they went to Safari or they went to Google Maps, is that that first usage, they were agreeing to a big trade-off. And they didn't realize the extent to which their data was going to be used as they accepted the convenience that these apps were going to bring to them. And now they're a little nonplussed that they have handed over all this information, and they find themselves in the middle of what I call the push and pull of privacy. And that is monetizing data while protecting privacy. And yes, I do think that people still believe they have a right to privacy and they deserve to have a right to privacy. And this battle has reached a fever pitch because the data is really valuable. There is a worth to your data. It is the bedrock of most of the tech companies' revenue streams, and it is how they leverage platforms against others. That is done by how well they can use your data to target ads to you that are going to yield a result for that advertiser. Plain and simple. And most of your big edge providers are great big advertising companies. The higher quality of the data sets, the more revenue that they collect, the more data they extract, the more competitive their offerings become. It is their underlying business model. There's a certain incentive to persuade customers to hand over as much data as possible, which is how we get to a place where companies provide pages-long privacy policies that are in teeny tiny print, and then they call that full disclosure. For a while, this complete lack of transparency worked, but now, with every subsequent data breach that occurs, or some of the, as we call them, weird new tricks that Facebook uses to target ads, people are really beginning to pay attention, and they're asking Congress, when are you going to do something about this? I think it's important to point out that the trade-off, which is exchanging data for access to a service that you want to use, is not inherently wrong. The problem is that these companies are using the complexity of their platforms to justify a lack of transparency. It is what they're hiding behind. I saw this coming when I was in the House, and it's why I introduced what was one of the very first privacy bills, and bipartisan privacy bill, in Congress. It was called the Browser Act, and it set up a fairly simple compliance framework that would allow consumers to reclaim ownership of their data. It required companies to secure an opt-in from consumers before collecting sensitive information about a customer's health, finances, or social security number, their PII. For less sensitive information, like an IP address, companies were required to give their customers an opt-out. Companies couldn't deny service to anyone refusing to waive the privacy, but the playing field stayed level because the bill required the Federal Trade Commission to apply the rules equally across the entire internet ecosystem. When I introduced the Browser Act in the House, Congress was not quite ready to act. The concepts of data and privacy were really very nebulous, and the debate over how to protect consumer privacy was kind of a niche issue. But now, half the news alerts that come to my phone involve technology or privacy or some sort of data breach. Consumers want answers, and it's become increasingly obvious that tech companies absolutely cannot self-regulate anymore. They do not have that restraint. The states have picked up on this, as we were just discussing. They understand correctly that not having a standard is unworkable, but now the country is on the verge of creating a patchwork of inconsistent regulations that would create a compliance bottleneck and cripple startups. One of the things we want to do is to preserve access to innovation in the entire internet ecosystem. California's new Consumer Privacy Act is a perfect example of a state-specific regulation that, starting in 2020, would micromanage every aspect of the disclosure and data management process. Amazingly enough, this law came to be as a result of a ballot initiative that was so terrible, the legislature flew into action to prevent another attempt. The bill that they came up with was also terrible, and they wrote and passed it with absolutely no input from the industry. What I'm working on recognizes that level of government interference is impractical, but it does take a cue from the states and tees up a consistent federal framework that won't create barriers to entry for new would-be competitors. I've repeatedly said that we must determine who owns the virtual you. Who owns it? You can pick out anybody walking down 14th or Pennsylvania Avenue and conclude that their online life, their transactional life online, has exploded over the past few years. That's why the question of data ownership is such a flashpoint for advocates. They know it's on the mind of everyone enjoying a new album or indulging in some retail therapy, all from the comfortable confines of their phones. They know that the free services that they enjoy online are somehow making money, and they've realized that they, the individual, the consumer, are the product in this process. So as a first step, I have reintroduced the Browser Act in the Senate. The key to giving consumers ownership over their data without destroying an entire industry is to be as clear as possible about what's being collected and how that data is being used, and then putting the choice to hand over that data back in the hand of the consumer. In the bill, I define what sensitive information is, explain how consumers should be given the option to withhold it, and then leave room for these companies to figure out the best way to engage with their customers. It will not eliminate all the questions, but it's a place to start, and one that avoids the overreach that tends to happen when Congress weighs into a more nuanced area of an industry. So, when is this going to happen? Which is what you all were just talking about. Well, that depends on several different things. The scope of questions we've been asked to investigate tells me the fix needs to be a collaborative effort that is industry-driven. It can't be a mandate, and it can't just pay lip service to the importance of innovation. The pieces are all there: a truly impressive product, an enthusiastic customer base, willing investors driving innovation, and amazingly enough, an industry that is now willing to work with Washington. If you're feeling skeptical about a lighter touch, I'll say this: Washington, D.C. is very bad when it comes to cultural change. They're just bad at it. I would never even attempt to write a bill that asks consumers to just trust Facebook or Google because Congress said they should trust Facebook or Google. We know they would not believe us on that. But what I will do is help give industry a guide that they can use to make whatever changes are necessary to get their businesses in a place where they're ready to ask customers to decide. Big tech needs to trust the American consumer to make a wise decision, which means big tech needs to be transparent with the American consumer. This is a two-way street. It's the perfect opportunity to resist the temptation to engage in regulatory overreach. I think that we should give it a shot for once and try to put something on paper and get it done this Congress. People can make their own changes and their own choices if they have all the information, and online consumers are going to do that. We don't need to panic and immediately default to controlling behavior. That's a lesson big tech needs to learn. The world truly depends on us having faith that the free market can adjust without tens of thousands of pages of mandates to force the issue. The accountability will be there in layers with Congress, with the media, with the consumers that we're agreeing to trust with their data. If something is amiss, it will come out, and companies know this. We can do just enough here in Washington to create a backstop, to let the industry and consumers know what transparency and choice and accountability really look like. And I have no doubt that with Commerce Committee and with Judiciary Committee, that is a journey that we're going to take and a product that we are going to deliver for the American people. Thank you so much. Thanks, Randy. I'll take a couple of questions, yeah. I know we've got votes coming up, and John's going to call time.
Okay, when John calls time, then we'll understand, but if we can do... Oh. Okay, do we have a question? One question. And, I'm going to ask Kelsey Griffiths from Law 360 for this one question.
Hi, Senator. Obviously, one of the big issues that have come up in regards to consumer privacy online is the issue of mobile tracking. Is that something that you think might be addressed specifically in an online privacy bill or in another bill on the side?
I think that privacy is going to end up being very narrow as you look at setting the guidelines, very much like what we've talked about with browser. One set of rules for the entire internet ecosystem, one regulator, the FTC, cannot deny a service for refusal on opt-in or opt-out. And those are the kind of guidelines that we need to give industry. Now, will there be a way to address data security? Absolutely, because it is important to do that for the data breaches and to put a framework in place. Should we look at censorship? Should we look at tracking? Should we look at antitrust? Yes, but having chaired the privacy working group in the House, which now took place about 6 years ago. Can you believe we've been on this issue for 6 years? And Loretta, you came for that for me, right? Didn't you speak? I think you spoke to that working group. We've been at this for a while. And I think that we would be well served to take these a piece at a time and come to bipartisan agreement so that we have guidelines that are going to last. It has taken quite a while to come to putting things in place for online privacy, and now consumers are demanding it. Yeah.
Okay, well, Senator Blackburn, I want to thank you for your remarks today, as always, but also for your leadership. You know, we're a free market think tank, as you know, and on all this issue and others like net neutrality and so forth. We appreciate your leadership from a free market viewpoint.
Absolutely, I am happy to do it and appreciate hearing from all of you. I do hear from many of you regularly, and I hope you'll stay in touch.
So, as a small token of our appreciation, look, you know, you've had maybe a ball cap and all that other stuff, and we're getting down to, you know, it's hard to find things to put FSF on, but what we have here is I said earlier I didn't want to be cheesy, but it's a cheese board. It's a cheese board, and we just want to give it to you to thank you. Hopefully you can keep it, if not, find a way to make good use of it. But I want everyone to join me in thanking Senator Blackburn for that. Thank you. Okay, you know, I've got the room for 5 more minutes before we have no. Well, this really is a great crowd, and I'm really grateful for all of you being here. Every time we do one of these, you know, I'm really pleased with the people we have and the way it works out. And our purpose is to be educational and informative, and I think we've done that today. So thanks for coming. We'll see you again next time, and you can keep those tweets going, but in the meantime, we're adjourned. Thank you.